The broadcast is now starting. All attendees are in listen-only mode.
Well, good afternoon, AFTA members and industry friends. Thank you for joining us on this afternoon's webinar, which is Business Administration 101. So today we're going to look at what you need to know and how to best avoid it. And to help us address this, we have Andrew, Ian and Vincent on the webinar from Aston Chace Group. And this is in assistance with Johnson, Winter and Slattery. And today we have Joseph in assistance from them. So welcome, guys.
Thank you, Jo.
Now, before I hand over, just a little bit of housekeeping. This webinar is being recorded and all AFTA webinars are placed on the AFTA website at afta.com.au/AFTA webinars. You'll notice that you're all in listen only mode. However, we do encourage questions. So if throughout today's webinar you do have a burning question that you want to ask, please use the question toolbox and we'll have time at the end to address those. So I'm now going to hand you over to our panelists who will take us through today's webinar.
Thanks, Jo. Just before we start, we're having a bit of an IT issue. We can't see our slide deck up on our screen. Are you able to assist there, Jo? Sorry about this.
Okay, so everybody on the call should be able to see the screen. Can you see the slides?
We can't, no. Anyway, what we might do is we'll just go off what we have in front, if that's okay.
No problems, and I can move the slides at this end.
That sounds great. Okay. I guess thanks everybody, and thank you, Jo, for inviting us along to talk to your members, especially in this current environment and COVID-19, and what that has done, particularly to your industry, where overnight your revenue has essentially stopped. Before I get into our webinar, I just wanted to make it perfectly clear that each of your businesses are different. Some of you are online only with little or no employees. Some of you might be bricks and mortar, and there might be a combination of both. So what we go through in this webinar might not necessarily relate to you, but it might relate to somebody else. So if you could just take that into consideration. So as I said, it's not a one size fits all, but hopefully it provides you with some guide. So if we go to the first slide, and this is skipping on to what can you do. As I said before, your revenue has pretty much stopped. So right now it's about buying time and understanding what your cash position is, because cash is critical. You need to, you're probably well aware of this, preserve the amount of money that you have so you can trade as long as you can to get to the other side of what's currently going throughout the world. So typically what we would look at, and again, this is because of all the, using the word unprecedented, it is, we would typically focus on what you can do operationally. So we would focus on practical solutions, whether it be your employees. And some of these suggestions that are here listed on this slide, you should seek legal advice because it might not be appropriate for all of you. But the things that we would look to do would either reduce casual staff, reduce their hours, let them apply for leave, either at half pay or full pay, but half pay you can extend their leave out. You can stand down the staff, and I think this should be okay, but again, seek your own legal advice because you cannot do it for the sake of reducing costs. You have to be able to show that standing down staff is either a health risk or you've been told to shut down, which effectively that's what the government's done by saying there is no travel. You can make people redundant, but that obviously has a cash consequence. So you need to look at whether that is an option and whether that is affordable. And again, negotiate reduced pay with staff. You cannot just say you're on a reduced figure, you have to negotiate. Given the circumstances, I would imagine if you have employees, they would be quite willing to get paid at a negotiated rate just to make sure they keep, they've got money coming into their bank account to live. And again, you can suspend benefits over and above your entitlement. So whether you're offering any sort of additional subsidies, whether it be childcare or car parking, anything that's above and beyond what you're entitled to, you can perhaps cease those things. If you've got a bricks and mortar retail footprint, look at what you can do there to reduce it. Look at any sort of exit strategy you might have, or negotiate a lower rent if you have to maintain that footprint. Given what's been released over the weekend, I think the federal government is saying you can't kick out commercial tenants for 6 months. And even if they did, I'd find it very hard for a landlord to find a replacement tenant. So I think it's in best interest, at that time you work with your landlord. But we can talk more about that a little bit later. Sale of non-core assets, in this environment, it's probably a little bit difficult to do, given the fact that it's right now nothing is entirely viable. So how attractive or the maximum amount of funds that you'd receive from the sale of non-core assets, it might not be a most appropriate thing to do, but it is a consideration. And then you also need to understand your loan covenants and the flexibility around those. And again, we'll talk more about that when you're dealing with stakeholders and lenders. So that takes us to the working cap. It's very important that you look at your debtors, you look at your collectability, if they are at all collectible. You might offer a discount to collect these monies now rather than waiting for them to pay in full. You can look at the commission structures. They might be payable at certain times, certain periods. You might ask to bring those forward. Again, being in your industry and everyone feeling the same crunch, it might be quite difficult to do, but these are all things that you can test. And one of the other things is that you need to obviously communicate with your customers around supply issues, around around their debts, around refunds in particularly. So you really need to get a good understanding of what that looks like. Suppliers, in the ordinary course, you would extend your payment terms. You would look to pay them a little bit later. If the terms of trade are 30 days, you might pay them, at later days at 40. But considering this is all new, it might be even further than that. If you're already in a difficult position with your suppliers or creditors, you can look to enter into payment plans, and then you can defer those payments to creditors. And this one might be a little bit tricky where you've got access to funding. Do you have any investors out there who know that prior to this, prior to COVID-19, that you had a viable business, an attractive business, that they're willing to invest money into your business to get it through to the other side of this? They might understand the fundamentals of it and know that it's a worthwhile investment. Again, it might be difficult, but it's worthwhile considering. And then the last point there is regularly update your cash flow model. You need to know your ins and outs. We recommend that you do it at least on a weekly basis, but ideally it'd be on a daily basis, just so that you're right across the money and you're able to know exactly how much money you've got in the account, knowing what your liabilities are going forward. So that takes us to stakeholder engagement. You need to talk to your stakeholders as early as possible, but you need to have a plan. And you need to, in doing this, you need to take them on this journey that you're going through. In many instances, in particularly lenders and landlords, I'm pretty sure they've gone through, I wouldn't say exactly this scenario, but something at a smaller level where they've had complications with their clients or with their tenants. So I'm pretty certain that they'd be able to, they'd be understanding of your current situation. But the idea with your stakeholders is to have a plan, have all your key information ready. So you need to go to your stakeholders, and I would suggest having worked through a scenarios matrix. So you've got one outcome here, one outcome there, one outcome there, but you need to have the support material behind it, which shows to your stakeholder that you're serious about this. This is your solution, and this is what potentially the outcomes could be.
And I think that's critical, Ian. The feedback that we are receiving from people that are having success around negotiating with whether it be landlords or their suppliers is that they're coming to them with a plan. I think those that are ultimately not finding success with those negotiations are the ones that are going to those particular stakeholders and just asking, what can you do for me? I think it's imperative, like Ian's pointed out, to be going to those stakeholders with a clear, defined plan and strategy.
Yeah, so Joe, if we could just move on to the next slide, the government assistance, and I'll hand over to Joe Garcella just to talk us through these.
Sure. Thank you, Ian. So the government's announced a whole range of packages dealing with COVID-19 to effectively hibernate the economy for the post-pandemic period. Besides all the stimulus packages that have been put out, the government's made an important clarification in respect of insolvent trading. If I just pause to note that most listeners will be aware that to trade whilst insolvent is to incur a debt when there is no reasonable basis to pay that debt in the future. So the government has said that for the next 6 months, provided you're conducting operations in the ordinary course of business, then there will be no liability for insolvent trading. Now that's only in respect of being sued for insolvent trading. However, the civil penalty provisions still apply. So if you incur a debt recklessly or knowingly for the purposes of defrauding a creditor, you still could be criminally prosecuted. Similarly, the tax officers offered deferred payment plans as well in respect of businesses and individuals doing that tough. And it's important to note that you should consider the ATO as part of the stimulus package, in the sense that the government, instead of giving you money, may be inclined to accept a deferral of payment. Now, with the ATO, it's always very tricky because an ATO debt is paid immediately upon assessment. So what you would do is you'd get an agreement with the relevant case officer of the amounts to be paid, and what you should be asking for is no interest to be paid, because automatically under the tax law, once you request a deferred payment, it carries with it interest. So you want to make sure there are no penalties associated with any deferred payment arrangements. And that's something that you should be getting to do right now, and getting in front of the ATO and asking for a deferred payment, because I think it's much easier from a policy perspective for the government to not collect cash rather than hand it out. Similarly, you should assess whether your business is entitled to any benefits, such as the $1,500 a fortnight package for employees, and also the depreciation and write-off benefits in relation to any capital expenditure. So, for example, if you know your business is going to survive the pandemic and come out strong, then today, now is the right time to engage in capital expenditure, provided you can remain solvent and it doesn't, as Ian mentioned earlier, depress your cash flow unnecessarily. The key point is that with all state and federal government departments, in respect of any obligations you owe to them, just be in front of that and make sure you speak to them in relation to those debts and enter into extensive payment plans and renegotiate them as soon as it becomes clear that you can't meet those plans. Having done a lot of work in this area in the past, what the government regulatory bodies hate is when you commit to a plan and then actually don't execute. So if you actually say, I can't pay my tax this month, but I'll pay it next month, if it becomes clear midway through next month you can't pay your taxes, you get in front. Don't wait for the default to occur, because you don't want to default. You don't want the ATO to write you a letter saying you're in default. Get in front of it, because then you'll have a much cleaner record going forward. So we would move to the next slide. It's one on directors' duties. Now, for those in the audience who are directors of their companies, this is probably the most important part of the presentation. Whilst the government has said that there's a moratorium on insolvent trading, as I've discussed previously, it does not alleviate any other duty you have under the Corporations Act or a general law. So the first thing to do is to note that whilst you can trade, even if the company is insolvent, there are things to consider. Are you trading in a way which is misleading and deceptive? In other words, do your creditors understand that you might not be able to pay them? Because even if you as a director are immune from insolvent trading, but you make a representation, either active or by silence, you could be held personally liable under the Australian Consumer Law, which is the new trade practices. The other important thing to note is once a company is getting close to an insolvency, it has a duty at general law to consider the interests of creditors. For example, if you continue to trade whilst insolvent, and that means you deplete the asset pool available to all creditors, then you could be breaching your duty as a director to those creditors because you are trading inconsistent with consideration of their rights. So that's important to note, that the blanket relief from insolvent trading does not relieve you from your other legal obligations. And if your company is of doubtful solvency, then you should seek help with an expert advisor to make sure that they can provide an assessment for you as to whether the company can enter into safe harbour, as we'll discuss later, or whether the company needs an immediate administration or so forth, or whether there can be a reconstruction proposal, as Ian has said, by speaking to all your stakeholders, getting them to put off their claims and paying off your debts later and collecting earlier. One thing you have to keep in mind in those discussions is everyone is in the same place as you are in this market. There's very few industries besides toilet paper manufacturers and supermarkets that are actually making a lot of money. So I think industry will respond and help each other because, you know, you've heard what the government said on Sunday night. They expect business to talk to each other and come up with a solution to help each other. So keep that in mind. The next thing you've got to keep in mind is that there is no alleviation on your duties to maintain your books and records. Now, under Australian law, you must maintain all the books and records that give a true and fair view of the financial position of the company. Now, if you don't, the company will be deemed insolvent if there's any recovery actions in the future. So the way you determine if your company's position is healthy is by examining the books and records. If you have no books and records, or they're not adequately maintained, you have no knowledge of whether the company's financial position is healthy, and then you could breach many of the rules in relation to your director duties. And dealing with your director duties, they're common law and they're enshrined into the Corporations Act, and you can read them for yourself. You can get, you know, any Google search, 180 to 183 of the Corporations Act. And the most important one here is probably 180 in sort of COVID-19 times, is that you must exercise appropriate care and diligence in respect of the management of your corporation. That includes, you know, cash flow management. That's ensuring you don't run it to the ground. And it is at least my view that if you take advantage of the insolvent trading provisions and you trade the company into the ground on a post-COVID-19 world, I can't see why you wouldn't be liable for a prosecution for breach of your care and due diligence obligations to the company. So you can't, so, you know, there's a huge misnomer in the market that insolvent companies can continue. The answer is the directors will be immune from prosecution under one section of an act which has 1,300 sections. But there is general law and there's the general provisions in 180 to 183, which the directors are likely to fall foul of if they trade insolvent without properly assessing the financial position of the company, having the books and records up to date, and taking advice from either accountants or lawyers. So if we move to the next slide as to what is insolvency, and Andrew will take that.
Thanks, Joe. So I guess the traditional definition of insolvency is when a company can't pay its debts when they fall due for payment. There are generally two primary tests to determine insolvency: the cash flow test and the balance sheet test. Under the cash flow test, the company is insolvent when it can't pay all its debts as when they become due and payable. So this means there is insufficient cash or other realizable resources available to pay all creditors at the various times that they can demand payment. Under the balance sheet test, a person or company is insolvent if total liabilities outweigh the value of the assets. Therefore, there are insufficient assets to discharge the liabilities. I guess in this current environment, businesses face cash flow insolvency due to effectively the disappearance of revenue overnight. A company can be cash flow insolvent, but still have assets sufficient to to pay out liabilities. It may be that creditors are, however, waiting some time for payment. Some of the traditional indicators of insolvency include continuing losses, liquidity ratios below 1, which is when short-term liabilities are greater than short-term assets, overdue taxes, inability to borrow further funds or to raise further capital, bank requests to reduce overdrafts, suppliers changing supply terms to cash on delivery, other special arrangements with selected creditors, etc. I guess, as Joe said, there are some serious consequences for incurring debts if the company is insolvent. So businesses need to be looking at a recapitalisation process, a refinance, obtaining equity, or potentially entering into safe harbour, appointing a voluntary administrator, and if none of that works, then potentially entering into liquidation. So I'll talk a little bit about the voluntary administration regime. And this is useful because, even if you are, entering into some sort of safe harbour or workout regime, then, creditors can still, potentially looking to enforce contracts and debts, and therefore companies should give, consideration to the voluntary administration regime. So if a company is insolvent or likely to become insolvent.
So just before we get on to that, I think, Joe, if you could just talk about safe harbour just there before we lead into voluntary administration.
Sure. Thank you, Ian. So the safe harbour provisions have been in the Corporations Act for a couple of years now. And if a company is of doubtful solvency or likely to become insolvent in the future, then instead of appointing an administrator, the directors have an option to put in place a plan, provided that in all the circumstances, the plan is reasonably likely to lead to a better outcome for all stakeholders, better than an immediate liquidation or liquidation or administration of the business. So what that means is that, for example, assume it's today and assume an immediate liquidation would bring 50 cents in the dollar to all creditors, then it is appropriate to continue into safe harbour if there is a plan that is reasonably likely to lead a better outcome than 50 cents in the dollar. Now, that's a very, very simplistic analysis, but what underlies that, in order to understand what your position is, you need to know what a liquidation or an administration position looks like today. Then you need to be able to execute a plan that's going to deliver a better outcome. And you're not going to be able to do any of those things unless you have adequate books and records, or as the law says, you're advised by an appropriately qualified entity. Now, an appropriate qualified entity is someone that can help you understand where the company's financial position is and help in respect of a potential either restructure or delivering a better return to stakeholders going forward. So the safe harbour provisions were enacted to allow directors to incur debts without being sued for insolvent trading. Now, it is my view, and it remains my view, that the recent amendments to the insolvent trading provisions that allow directors to willy-nilly incur debts when the company is insolvent is unwise in the absence of a plan under the safe harbour regime. And the reason for that is as follows: because if your safe harbour plan is executed and works, then there's complete immunity from insolvent trading. But if it doesn't, then you've got the immunity that the government's given in the last 6 months. But what the purpose of the plan, it means that you are genuinely trying to improve the position to all stakeholders, and therefore that is likely, if done properly, to adhere to your duties as a director. So that's something which I said earlier. So it's quite important that if you are of doubtful solvency, you don't simply trade on, but you get appropriately qualified person to assist you assess the financial position of the company and help you put together a plan that might lead to a better outcome. And during the course of that exercise, it'll become clear whether a better outcome is likely or if the company is best placed into a form of external insolvency administration.
So if the company is insolvent or likely to become insolvent, then the directors of the company may appoint voluntary administrators to take control of the whole company with a review to resolving the company's future quickly. So unsecured creditors cannot enforce their claims against the company without the consent of the administrator or the court. So that's one of the key benefits. Landlords cannot recover their property. Another benefit, although noting that the introduction by the government is also assisting in that regard. Secured creditors cannot enforce their security except in some limited circumstances, and personal guarantees cannot be enforced without the court's consent.
So just to also add that it could be a good opportunity at that time to get out of onerous contracts or leases, where before you were thinking about reducing your footprint, but if you are placed into a formal administration process, you are then able to exit out of those, or the liquidator or administrator is able to disclaim those leases and exit those agreements.
And as the slide outlines, one of the key reasons and purpose of the voluntary administration regime is to maximise the chances of the company, or as much as possible of its business, continuing in existence.
I just want to highlight some of the risks there. They might be different now because a lot of people are struggling, but there is potential brand and reputational damage if it does go into administration. And looking at AFTA here, I'm not sure what their view is around their accreditation process and what that means to you if you should experience insolvency or a decline in your financial position. I think that would probably, being a key stakeholder, I think AFTA would be wise to talk to them about maintaining your accreditation as long as you've got something that ultimately sees you work through your current situation. You might have a loss of key stakeholder point, and that goes to my point around AFTA and being a member, being accredited, being afforded that accreditation. But ultimately, the vote or outcome, sorry, the outcome of the business is down to creditors. They vote on the outcome. We'll take you through a timeline of events of how this works, but there is a decision meeting where options are put forward to creditors, and at that time a decision is being made on whether the company continues in some form, whether it's wound up, whether the company is given back to the directors, and that might very well happen if the company is still viable and is able to get out of its position quickly. But again, they're the options that are available, and we'll talk a little bit more about that in the coming pages. So that takes us, one of those options I spoke about is a deed of company arrangement. I'll pass to Joe just to talk about the purpose of the deed of company arrangement, what that involves, and the options that are available under a what we call a DOCA.
Thanks, Ian. So when a company, as Ian said, goes into administration, there's three alternatives that may be voted upon. The first is the company gets placed into liquidation. The second, which is the least likely, is the company returns to the directors, because if a company is insolvent, it ought not to. And the third option is that the company executes a deed of company arrangement. Now, it's otherwise known in industry as a DOCA, but a DOCA is a statutory contract which allows you to compromise the debts of your creditors as well as achieve a restructure. Now, traditionally, DOCAs have been used for where a business is viable, but it's being constrained by something as Ian mentioned earlier, burdensome contracts or burdensome supply agreements or leases, and it needs to get out of them in order to sustain. The objects of company arrangement is to facilitate the business or any part of it to continue into the future and to clean the company of all its liabilities so it has a fresh start. And this has been in place since about 1993, and it has been the most used mechanism to achieve restructures. And DOCAs are very, very malleable instruments, and they can be adopted to almost any circumstance. In particular, in the current market, DOCAs would be useful, for example, if you're subject to burdensome leases, you might be able to enter into a DOCA and compromise the claims of landlords. if you're under burdensome supply agreements, you might be able to enter into a docker and compromise those supply agreements. But the idea is that the business tries to continue in a new form. If the business can't continue in a new form, then the secondary operation of a docker is to ease a smooth transition to effectively, sell down the assets of the company and pay creditors what they're owed, and that'll be proportional. The advantage of a docker is it allows funding to come in from third parties that creditors ordinarily would not be entitled to, such as directors, shareholders, or a white knight. Dockers have also been used as an M&A tool to acquire businesses and clean the debts out post-acquisition. So they're some of the most, that's a full range of use. But where we see a docker being useful now is what is known as a holding docker, or a docker that tries to suspend the operation of the company insofar as its creditors are concerned. Now, holding dockers are a tricky instrument, and they need to be done very carefully, and you need to be carefully advised by your financial and legal advisors, because not all holding dockers are legal. But provided a holding docker has the intention of preserving the business and delivering more to creditors than they would in a liquidation, then the general consensus is that is a viable means of restructure. The way it would work in the present circumstances is if you're in the travel business and you're a bricks and mortar retailer, you could enter into a docker for a period of several months to preserve the obligation to pay creditors past debts, so you can effectively hibernate your business till you can come out the other side. Now, the trick with that is that landlords and other suppliers will want to be paid if you continue to trade the business. But you could enter into fresh agreements outside the docker with landlords and with other suppliers to say, we'll pay you a particular percentage, then we'll either make it up or you'll share in any spoils we get post the COVID-19 situation. So what, it's too complex to go through in immense detail over a webinar, but what you can do as an appropriately structured holding docker can help hibernate the business and see you come out the other side without too much value destruction. And what it could also do is help you get rid of any unfair contracts or contracts which are hurting the business, so when you come out the other side, you don't have a cash stream. The benefits of the docker obviously is the extensions of time in which you can obtain credit terms or pay your creditors. You can compromise claims of creditors, and of course, potentially you can move the business out into a new structure, leaving old debts behind. Provided that's done appropriately and for appropriate value, then that's entirely, entirely legal. It can be done, subject to abuse if not done appropriately. So therefore, that sort of heightens the need for you to get appropriate advice. The concern with the deed of company arrangements are that they must be voted upon by a majority of creditors in number and in value. So if the proposal you're putting forward makes no commercial sense to the creditors, then it will be voted down and the company will go into liquidation. So when problemating a docker and considering going into administration to reconstruct the affairs or hibernating the business, you must be reasonably comfortable that the proposal is of such strength and such appeal to creditors that they will vote in favour of it. Because the downside risks are that creditors vote against and the company goes into liquidation, and the liquidator will then investigate the affairs of the company and bring any prosecution actions. So which takes us to the next slide.
Thanks, Joe. So once voluntary administrators have been appointed, they must hold a meeting of the company's creditors within 8 days of being appointed, unless the court grants an extension of time. The voluntary administrators must investigate the affairs of the company, including as to its property and financial affairs. Unless the court grants a further extension of time within 20 days of being appointed, the voluntary administrators must hold the second meeting of creditors. And it's at that second meeting of creditors that one of the following three options voted upon by creditors. Either the company's return to the control of the directors, ending the voluntary administration, the docker is agreed upon, or a liquidator is appointed to the company to wind it up.
So just looking at that slide and that timeline, there's periods in which you will use to develop your potential outcomes. So you look at all your different scenarios, you'll use that opportunity to be able to work out what your proposal may look like as a proposal for a deed of company arrangement. The holding docker also will give you the opportunity to explore those restructuring opportunities. So right at the point of the decision meeting, you might not have the entire proposal worked out, but you're of the view that there are some things out there that you need to consider, or the company to consider to come out through that other side, and that proposal then being put to creditors. So this process, typically, it can take anywhere between 3 to 6 months. It can take longer depending on the complexity of the job. You know, I guess the number of creditors, the level of debt, and the number of stakeholders that are involved. It can take some time, but typically it takes 3 to 6 months. A holding docker could take that length of time or longer, just depending on what you've agreed in terms of your milestones and ultimately the outcome. So this takes us to the last slide, where we're looking at practical recommendations, and it's pretty much a summary of what we've spoken about. It's in order to make sure that you work through this issues, your issues, or a company that's in distress. You need to hold regular board meetings. You need to monitor the development and the implementation of a workout plan. It's important that you consider those options of what you can do to save the company and to assess the company's solvency on an ongoing basis. You need to look at what the next phases of your restructuring plan are. Some things might change where you need to quickly move to adjust to that situation or event. You know, there might be new assistance packages that come out from government that might make things that weren't previously viable now viable. So you really need to be right across all the material, all the information of what your company is doing, and understand, in particular, like I mentioned before, making sure that you're aware of your cash flows, but also that support material behind that makes that forms that cash flow. There's no point putting things into that cash flow that doesn't make sense, because people will pick it apart. The banker, the lender will pick it apart. So you really need to have that information there. And introducing an accountant or an advisor to help you with this process will get you some way. You need to, as I was mentioned before, you need to document everything that you're doing. This helps for a number of reasons. It helps you look back in terms of your history and the things that you've attempted. It protects you from any legal actions you've attempted to do the best thing with respect to the company. So you need to make sure that all your documents are kept up to date and all the steps that you've undertaken are properly documented. But when it comes to an insolvency appointment, to make it as effective as possible and also to reduce costs, it's important that all the financials are brought up to date. Now, I guess that goes without saying whether you're continuing to trade or not, but all the financials should be brought up to date. That cash flow is also important for a voluntary administrator. They need to know whether we can continue to trade the business, whether there's going to need to be a funding injection, or whether we need to find other sources to deal with the ongoing trade, or maybe even sell the business as a going concern. Compile all creditor claims. We need to know who to talk to with respect to creditors. Need to know the quantum and who they are. So we've got a clear understanding as to the company's issues. Listing out key suppliers. So if the business is trading on, we need to have those early discussions with key suppliers to make sure they continue to provide support. Insurance policies, including D&O, these things we all need to make sure that everything's properly covered. We as a matter of practice, we have our own insurance, but ideally we'd like to just tap onto what's already put in place. Understand your employee entitlements, and this goes to a couple of things. If the company should go through a deed of company arrangement, we ultimately would like to know the value and number of employees. They are accredited and they have a vote, and we want to make sure that if a proposal is going to put forward that makes commercial sense, that we have the support of all the employees. And then I've got here username and password to accounting software and bank statements. That helps us with our investigations. We need to issue a report to creditors for the decision meeting, so creditors are informed as to whether the recommendation that we're making as administrator makes sense for them to either vote in one way or another, whether it be to accept the deed of company arrangement or liquidation, or although unlikely, hand back to the director. And again, understanding who your key stakeholders are. So that the discussions that we can have are made early on and that we get their support. Everything is on their support in terms of making sure that we can get through the other side of an administration process. So that ultimately wraps it up. Given that the environment is constantly changing, I just want to make sure that the message that we're giving is that it's important to buy time in this process, and it's also it's crucial to preserve your cash. So if there's one thing I want you to take away from that, it is that. So I'll just finish up now, Joe, and hand it to you for any questions and answers.
Fantastic, guys. Well, we have all of your details up on the slide, so no doubt some members are frantically writing down some numbers. I will just have a look now at the question toolbox because we have a couple of questions that have come in. And the good news is everyone could see the slide, so that's great.
Great. Yeah.
And I'm just looking at some of the questions. I've got a question from Mayor who's asking with regarding to BAS for June to March, do they have to fill it out in the normal way and remit group tax /GST?
Yeah, otherwise if they don't adhere to the normal lodging practices, it becomes a personal liability.
Great, thank you.
There's new rules that have come in that failure to pay GST you can issue penalty notices to directors and they will be personally liable for that, and that law just came in as of this week. So you've got to continue to lodge your BASs and keep that up to date. If you can't afford to pay, lodge, but then enter into payment arrangements with the ATO.
Yeah, I think also that depending on what state government or what jurisdiction you sit under, I know, for example, that New South Wales have waived payroll tax. I've forgotten the threshold of what your income is, but I think it's $1 million in terms of employee revenue. I'm not sure. I think it might be slightly higher than that. Yeah, it might be slightly higher. No, I don't want to confuse people, but there is a waiver out there. I think it's best that you look at those appropriate pages. There's a lot of advice out there that you can talk to on that matter, but there is a waiver for the next 3 to 6 months, especially knowing that the New South Wales government have been pretty proactive on this.
Yeah, I'm pretty sure it's actually, I thought it was 50 mil for small businesses, so that's probably the majority of people, if not everyone, on the webinar today. That would be applicable for. So definitely something that we're looking into.
So I've got a question here from Susan, just wanting clarification around the difference between going into administration and liquidation. Is there a difference?
There is. So voluntary administration, as we spoke about, gives you the option to put forward a proposal. So that's where we spoke about the voluntary administrator, the options of accepting a deed of company arrangement or alternatively place it into liquidation. When a company goes into liquidation, it's as it sounds. The assets are, the company's wound down and the assets are sold or liquidated. So liquidation, consider it as being terminal. Voluntary administration to a docker, the business gets to live on in a restructured form coming out the other side.
There's also obligations for a liquidator to investigate potential actions against directors when it's not necessarily the case through a voluntary administration process. That's also something to be mindful of.
And then Stephen's asked that if we're in administration and permitted to trade, does he or do travel agencies to let their new customers know about this?
So yeah, so what it won't be the directors trading the business once it goes into voluntary administration. It would be the administrators who have been appointed to that matter. They're the ones that will trade that business on, and they would ultimately look at the viability of that business. We would, as a matter of course, have to write to all creditors, customers, and let them know that we've been appointed and it is under administration. So you'll see in correspondence that goes out, it'll be XYZ Proprietary Limited in administrators appointed. Sorry. So you will have that detail there, and we need to inform all those that are stakeholders in this business that an administrator has been appointed.
And in fact, it's illegal to issue communication on company letterhead without referring to the fact that the company is in administration.
And then a question here from Lionel. If you don't feel you can cover costs and debts in 6 months, should they be seeking safe harbour now or voluntary administration? So this is looking down the future and thinking that you would run out of money down the line.
So on both of those instances, you'd need to engage with people like us and lawyers like Joe. But there's no point delaying in the sense of if you've got safe harbour, if you think at the end of this you're going to need to do safe harbour, you should really look at that now. I wouldn't wait because, like we said, the fact that you've got 6 months reprieve from insolvent trading doesn't mean that you can absolve your obligations as a director or your duties as a director. So if you're thinking that you're likely to enter into some sort of, whether it be safe harbour or voluntary administration, it's better to get in there early so that there's you can properly assess the situation rather than waiting to put it all falling into a massive heap right at the end, and it all becomes very, very difficult, costly, and the outcome is likely to be worse.
Yeah, so it's Joseph here. In this game, there are no prizes for trying to be a hero. This is like a flood or a fire. You know, you don't think if you think unless you know you can beat it, you shouldn't, because obviously the downside risk is significant. The law encourages people to do the right thing early, directors to do the right thing early, rather than being asleep at the wheel and hoping it's just COVID-19, things are going to be okay. So if you're not sure whether your business will be okay in the future, then it's now's the time to engage. The sit and wait approach might not be appropriate for your business. Like it's like inside the start, everything's it's not one size fits all, but you would need to have a look at what your business, what your suppliers look like, what your debt obligations, what money you can raise, what plans you can put in place. You have to look at all of that, along with adequate and properly kept books and records to know whether you're going to come out on the other side. If you think you are and you've got a good basis, then you should go into safe harbour. If you're not sure on whether you will survive at the end of this, then you should really engage with external experts to help advise you as to whether the business needs to go through a process now, goes into safe harbour, or whether it should just ultimately be liquidated now because there may not be any benefit in throwing more money into it.
And I guess a good indicator would be what was happening to the company or business prior to this current environment. So if it was already borderline before COVID came along, the chances are, in 6 months' time or whenever we exit out of COVID, that you're going to be in exactly the same situation, if not worse. So yeah, if it was me, I'd look at actioning now rather than waiting for it all at the end of the outcome of COVID-19.
And then I've got just a question/statement from Ken. He said, many AFTA members are sole traders or employee of only a few people. So are these solutions also applicable to small businesses? Because the DOCA, for example, seems to be more suitable for medium to large size businesses. What do you suggest the focus would be or should be for small businesses?
Look, the rules are the same for all businesses. And the DOCA or the administration process is intentionally wide and malleable to apply to the corner shop as well to as an ASX listed 100. So it can be applied to all. So it should not be a deterrent if you're a small business, to think, oh, well, that's just for a business bigger than mine. It applies uniformly to all corporations, whether they're a $2 or a $2 billion corporation. And I would encourage those who, even in the smaller businesses, to seek help now rather than wait until the end of the COVID-19 hibernation period.
So a question from Melanie then, what is the process to go into Safe Harbour?
Okay, well, to go into Safe Harbour, the first thing you need to do is you need to have adequate books and records. You need to ensure that your employee payments and your tax payments are up to date. If that's the case, then the directors of the company have to form a view that the company may be insolvent or likely to become insolvent. That's step one. If that is the case, then they must commence formulating a plan to deliver a better outcome to stakeholders than what an immediate liquidation or administration would look like. So effectively what that means is you go to people such as Aston, Chace, and you ask them, run a cash flow analysis. What would a liquidation of this business look like now? And then work with someone like them to say, what levers can you pull to improve the outcome to creditors and stakeholders? And then if there are levers you can pull and a plan you can put in place, then you implement that Safe Harbour plan. It needs to be appropriately documented, and you should need to follow that plan and adjust it accordingly. So there is no real formality other than satisfying yourself that you've put in a plan that is likely to lead to a better outcome than an immediate external administration. Though, whilst there is no formality in the legislation, we strongly advise that you actually have that plan recorded, and you have milestones, and you tick off those milestones when they're met, and if they're not met, explain the reasons why, and adjust the plan accordingly.
Joe, I was just thinking that maybe perhaps after this, so we could send to you a one-page summary of what a Safe Harbour looks like and that process looks like with a little bit more detail, and you can pass it on to your members.
That would be great. We will put this webinar recording on our website, and we'll put the slides up, and I can also add that Safe Harbour document to that so members can access it. So
Sure.
Melanie said, yes, please. Thanks, Melanie.
Hi, Joe. This is
Hi, Naomi.
hi, it's Naomi Menon here, Head of Compliance and Operations at Aston. I was just wondering, Joseph, if you could just touch on that previous question about sole traders, and maybe just clarify that sole traders enter into bankruptcy rather than administration, because we do have a lot of members that are sole traders.
Yes, that's right. So if you're not trading via a PTY LTD via a company, but you're a sole trader, there are mechanisms under the Bankruptcy Act, such as Part 10s or Part 9s, which allow you to compromise your claims with creditors in return for, it's effectively like a docker for individuals, but it has a slightly, it has more formality associated with it. But again, if you are a sole trader, you should be reaching out to your legal advisor, accountants, or someone such as an Aston Chace to deal with your financial position. It's effectively the same. There are no Safe Harbour style provisions because you're obviously personally liable anyway, but there are mechanisms which you can actually do effectively something akin to a personal docker under Part 10 of the Bankruptcy Act. Like I said, it's a little bit more formal. It's more rigid than the voluntary administration process, but it is viable. And I would hasten to add that you'd probably find a lot more understanding creditors in the current environment than you would if you hold on and do this in 12 months, because most people would be saying, you traded during COVID-19 when you shouldn't have, and now you've exposed us all effectively. So people are going to be likely to be more sympathetic to a restructure proposal now than they would in 6 or 12 months' time when the economy resurfaces and hopefully, this virus is contained. So you've got to keep that in the back of your mind as well.
Yeah, and just to add, this might add some comfort, it's around the ability to wind you up or seek demands for payment. Now, to enforce, the limit's gone from 2,000 statutory limit to 20,000. And I think you have 6 months now to respond to something.
That's correct. It's
Like statutory demand.
21 days.
Yeah, instead of the 21 days. So there is a little bit of leeway there, but again, like Joe says, if you know what the outcome's going to be, it's better to do it sooner rather than later.
Thanks, guys. I've just got a few more questions I'd like to address. This next one's from Teresa, related to lease contracts. She says, where the director has signed a personal guarantee on a lease contract, does the company as well as the director must declare bankruptcy in order to avoid any penalties or lease?
Look, under the Corporations Act, if a company is in administration, no claim under a guarantee signed by a director can be prosecuted during the administration period. Not during the DOCA period, but during the administration period, which usually lasts about 20 business days. So if a company goes into administration today, then landlords won't be able to enforce a claim against the director under a personal guarantee for the time during which the administration subsists. That gives a director some breathing space to go around and try and do a deal with a landlord, or otherwise raise money in respect of the personal guarantee obligations. And if he or she can't, then to determine whether they need to enter in some form of bankruptcy proposal or other arrangements to satisfy the landlord debt.
Yeah. So if a company goes into liquidation, personal guarantee can be called upon. But I think in this current situation, and I don't know exactly the answer to this, but the idea would be to work hand in hand with the landlord to minimise any effect on yourself personally.
Thanks, guys. I have a question here from Anne, just asking if there is a website for up-to-date tax information specific for Victorians. Do you have a website you can recommend?
Just the ATO website, just ato.gov.au, and then they'll have microsites of COVID-19, and also everyone should also download the COVID-19 app as well.
That app actually does have that information on there, so I do recommend getting it.
Sets it out quite clearly as well.
Great, and is that relevant for Victorians as well? So nationally relevant?
Absolutely. Any of the larger accounting firms will also have this information, but yeah, I would go directly to the ATO or that coronavirus application that the federal government has put out.
Great, thanks, guys. A question from Maya again. If our small businesses, travel agencies, if they're unable to pay back commissions to the client, will this be regarded as insolvency? Do you have an opinion on that?
Look, it's impossible to say without looking at the individual circumstances of the case, because unhelpfully, the case law on insolvency is factually relevant to a particular company. For example, the most extreme is a company which was found to be insolvent because actuaries determined that it couldn't pay certain payments in 15 years' time.
Right.
Whilst a company, depending on the nature of the company, a company that cannot pay a debt today might be deemed insolvent. It all depends about the nature of the industry and the circumstances of that particular company. And it's a very complex question of fact and law. But if you can't, the general rule is if you can't pay your debts as and when they fall due, then that's the clear warning sign that you might be insolvent.
Right. Okay. Thank you. And I have flipped the presentation slide over to the page that has your guys' emails on it. So you may wish to reach out to them to discuss further.
Yep.
I have a question from Lisa here. She's obviously from a tour operator business, and she said, as tour operators with some clients are requesting cash refunds, and they're aiming, so she's a travel agency, but a tour operator, I'm just reading the question here, apologies. So as a tour operator with some clients requesting cash refunds, we are aiming to keep as much cash as possible. Like most other operators, we want to offer a credit voucher for the future And so 70% is our preference, but there's a pressure to do 100%. And here's the question. Either way, I understand it would become a credit in accounts receivable on the balance sheet and a negative sales in the profit and loss. Is that correct? Do you need me to repeat the question?
Yeah.
That might be an accountant question, I think, Lisa.
Yeah, look, I think that the whole thing around refunds and credit, that's entirely up between you and your customer. But I can't speak for how the treatment of that is in terms of the accounting.
And I think having read that question out loud, I think that, Lisa, you're probably best to loop back to your accountant and ask that how that should appear in your balance sheet.
Yeah.
This is a question from Justine, and I'm not quite sure if it's relevant for this forum or perhaps for Friday's webinar with Jason Westbury, but it's a question around operational structure and whether you can enforce staff to take leave and annual leave and long service leave given the JobKeeper payment has now come in.
No.
Something you can address?
I can't answer that entirely in that clearly. It's a case-by-case situation. I would recommend seeking employee lawyer legal advice. You don't want to get to do or instruct something to get in on the backside once it's all finished.
Justine, I might take.
But just on a whole, I think if you can negotiate that with the employee and they agree to it, then that may be okay. But again, I'll be seeking legal advice on that.
We have a HR workplace advice line, and that would be the best place for you to ask that question.
Thanks, Naomi. Justine, I will send you the details of that HR workplace contact. And also, we've got a question on Michael around the JobKeeper allowance. Michael, I will loop back to you on that question. And for everybody left on this webinar, I will mention that tomorrow at 1 we have a dedicated JobKeeper payment webinar. Unfortunately, it's full, but Jason is doing a Friday weekly wrap-up at 2 o'clock. The webinar registration details are on the AFTR website. And in that webinar, he will also address the JobKeeper payment. So no doubt, if you join that, we will answer many of the questions you have around the JobKeeper payment and how that works and how it's relevant to you. So I do encourage you to join that webinar. But for anyone that's got specific questions on here, I will loop back to you separately outside this. So, gentlemen, that concludes today. I've got a lot of people saying thank you very much. It was very helpful. So, Joseph, Andrew, Ian and Vincent, thank you so much for hosting this webinar for today and providing a lot of information to our members. And your details have been provided, so no doubt some of our members will reach out to you.
Thanks, Joe. And yeah, we're definitely available to your members in their situations.
Thank you very much.
Thank you. Thanks, guys.
Thank you.
Thanks.